Welcome back, everybody, to the CloutHub show. My name is Terry Hansen. It's great to be with you once again on this beautiful Friday. I'm excited today for this episode because today we have a special guest, Ron Coleman, here with us. Ron Coleman, as many of you may know, he is a partner at the law firm Mandelbaum Salzburg, where he has practiced commercial litigation for more than 30 years. He, over the years, has really developed an international reputation related to the intersection between technology and internet-related law and free speech, and sometimes it's abuses. So we're excited to have Ron here with us. And an interesting note is in 2017, Ron appeared before the U.S. Supreme Court on behalf of Simon Tam and the ban the slants, which resulted in really a pretty historic First Amendment ruling. So we're excited to have Ron here join us today. Ron, welcome. How are you today?
Thank you very much. I'm good, thanks. Beautiful day here in New Jersey.
Good. Well, it's most days are beautiful in New Jersey, so it's
okay. I'll go with
that. Sometimes, right?
Yeah.
Well, it's great to be with you. Now, I know you specialize really in First Amendment law and free speech. It seems like such an interesting niche to be in our country. I have to ask, whatever I guess prompted you or motivated you to specialize your practice in just this little niche area?
Well, I will tell you, first of all, I don't want to get in trouble with the bar authorities in either New York or New Jersey, where I'm admitted. We don't have specialties here.
Okay. Well, good correction.
But I do. My practice does include a lot of law having to do with First Amendment rights as well as free speech in general, and they're not the same thing necessarily. And we'll talk about that, I think, in the course of our discussion today. I've always been interested in free speech. I mostly because I couldn't keep my mouth shut, and I had a lot of observations to make, and I do come from a family of sort of radicals. I ended up being sort of an early adopter of the internet, and very quickly found myself involved in one of the early internet free expression cases, which involved a domain name.
Oh.
And as time has gone on, because I had always been doing intellectual property work, I generally describe my practice as commercial litigation. I have a special interest in the internet, special interest in free expression.
Yeah.
One of the things I've gotten very involved in over the years has been the use of the law to silence expression, whether under the guise of trademark or copyright infringement or unfair competition. And more recently, I have been very active in the area of deplatforming, where people form advocacy groups or where, and then pressure platforms such as Facebook or Twitter or YouTube to pull people off the internet because the ideas that they're expressing are considered to be unacceptable according to some standard. So it's been sort of an evolutionary process, and I'm very happy that I'm able to combine my general commercial practice with something that I really have a passion for, which is the free expression work.
Oh, that's awesome. Well, wonderful. It's we're seeing a lot in the media right now about that very thing. So I'm sure you're as busy as could be as it relates to that. Now, take us back, several hundred years here. When the founding fathers put together the Declaration of Independence. Give us just a quick, maybe short history lesson on free speech. What was it intended, for initially and originally, but then most importantly, obviously, is how has it evolved and changed, particularly maybe over the last 10 to 15 years. As we all know, just
Sure.
Because how things start doesn't mean that's how it is today in 2019. So
well, that's for sure. Our conception of free speech and free expression, just like our conception of freedom of conscience with respect to religious practice, is a very, very modern phenomenon. In Europe, the idea of free speech was something that philosophers began very carefully and very quietly to play with. Only during the 1700s, every place where a religion, where there's a state religion, which until fairly recently was every place, had laws prohibiting blasphemy and protecting also the the person and the office of the monarch and of the church or the caliphate or whatever the case may be. That only began to change again in the 1700s, and the First Amendment was added to the Constitution along with the Bill of Rights in the United States in 1791. The Constitution was ratified in 1789. Nobody thought at the time that it was such a big deal. It wasn't, first of all, it did not apply to the states until well after the 14th Amendment, which the Supreme Court subsequently in the early part of the 20th century ruled incorporated the rights of the Constitution into the states. So there were, for many years, blasphemy laws, religious tests, anti-obscenity laws, and also the concept of free speech as we have it today. The very broad category of things that are considered to be speech were just far beyond the conception of what was protected under the original conceptions of the First Amendment. I mean, fundamentally, the Supreme Court didn't get involved with a free speech case until, I think, well more than very, very late in the 1900s. In the beginning of the 20th century, the court begins to formulate this idea that prior restraint is different from being punished for your speech. And the idea was that you can still be punished for expressing yourself subject to state law, but we're going to read the First Amendment as saying that we will only restrain someone from speaking if there's a clear and present danger that arises from his speech. Clear and present danger of what? Well, it could be clear and present danger of violating a law that prohibits that speech. Again, nothing like the concept that we have now. Just to scoot ahead.
Yeah.
Development continues apace through the 30s and 40s. And war is a bad thing for free speech because it tends to make societies understandably nervous about dissent. The problem with that is that you need to dissent from the question of whether you want to be having the war or not.
Yeah.
But that's the way it goes. So you had the Alien and Sedition Act. You had, which prohibited and was enforced to prohibit dissent from war. Basically, though, in the middle of the century, things begin to gel into a form a lot more like what we're familiar with. The 1960s saw a gigantic explosion in the conception of what constituted free speech, what kind of expression was deemed to be free speech.
Right.
And ultimately, I know the case that you mentioned where I represented Simon Tam of the Slants, the Supreme Court ruled that the United States Patent and Trademark Office, which was one of the last parts of government that had any speech restricting duty whatsoever, could not withhold the trademark registration on the ground that it disparaged people.
Mm.
They said that's not government's job to decide what's good speech and what's bad speech.
Right.
So we're at a point now where I think it's fair to say that the challenge in free speech is not what government will censor, but rather it's what non-government entities will censor. And in some cases, what non-government entities will censor at the behest of governments that are not in the United States and that are not subject to the First Amendment.
Well, and that's interesting because originally in the 1700s, that's all it was. It was we say whatever, as citizens, we say whatever we want in essence, and the amendment protected us from government coming in and slapping our hands and saying, don't talk mean about us rulers, etc. That was the protection. But here, 2019, it's all changed. It's not so much about what we can say against government and that sort of protection. It's kind of private enterprise and it's everything all around. Is that correct?
That is correct. And I mean, on the one hand, not only can government no longer prevent you from saying almost anything. I mean, and that goes even so far as to have affected the concept of obscenity. I mean, it's still technically speaking, obscenity is not a form of protected speech, but almost nothing is considered to be obscenity. And frankly, as a technological matter, it's probably just as well. It would be a tremendous waste of resources.
Oh yeah, to try to define and litigate all that. Yeah, mess.
Yeah, no, impossible. But what we do have now, where it's reached the point actually, to finishing my thought, where courts have ruled in where I practice in New York in the Second Circuit that a government entity or even a government personality like the President of the United States is prohibited by the First Amendment from even blocking people who are bugging him on Twitter, because you have a free speech right to be able to, troll the president.
Interesting.
Now, on the other hand, though, everyone knows that there is an issue with people being kicked off social media by the private companies that run them, often at the behest of third parties, or even sometimes, we suspect, foreign governments. And there's nothing, in my view, and I think the view of almost everyone who's considered the issue, who knows anything about it, the Constitution has nothing to say about that. And that doesn't mean it's not a problem.
Right.
Doesn't mean it's not an issue. And it also doesn't mean that there might not be some legal solution for people, but it's not going to come from the First Amendment.
Right. Well, I know in the mid 90s, 96, I believe, this whole question of if you're a content creator, if you're a publisher, if you're someone who's got a message to share, you're kind of generally speaking titled or considered as a publisher of some sort of message, right? But then you've got this differentiation between a platform like Twitter, like Google, like Facebook, some newspaper, a platform that shares that message. And in the mid 90s, there was the Communications Decency Act. And I know in one of those sections, Section 230, there was some specific things set up differentiating between publishers of, publishers of messages and platforms that share that message. Can you just tell us what the heck that Section 230 really is all about, and how it kind of affects what we're seeing, today?
I can try. I have spent a little bit of time thinking about this. Section 230, publisher and platform are really 21st century terminology that we're putting back on Section 230. What you're talking about in particular is very important. We wouldn't have the internet as we know it without the provision of Section 230 that says people who are ISPs, internet service providers,
right,
which was understood to mean not only companies at the time such as AOL, CompuServe, good old days.
Yeah, CompuServe. Yeah, right.
But not only people who run a sort of a general internet service company, but also people who have what used to be called bulletin boards, which are definitely the forerunners of our modern forums, our modern social media. They should not be held responsible for violation of the law, such as libel, defamation, because they're not. If they're going to have a platform, they're going to have a bulletin board, a chat room. We don't want to put them into the position of having to monitor what everybody says. It'll throttle the discussion. So the general rule is, as long as they are not actively involved in curating content, they are exempt from liability for the conduct of third parties. That's not the conduct of third parties is not really where the action is in terms of internet problems. And in terms of free speech on the internet, because as a general rule, it really has mostly to do with defamation, and defamation is essentially a non-existent cause of action now. Now, I am involved in a defamation case where I'm representing a Gaffney McInnes in Alabama. That's one of the rare cases in my view, and I've spent years mostly defending and getting rid of defamation cases, but where there really is a legitimate defamation claim. But most defamation claims don't have legs. People don't understand what the elements of defamation are, and judges are very hostile to them, especially here out east, and northeast in particular. Third-party conduct, however, isn't really the problem. There's another provision of Section 230, however, that people don't tend to know about, and that is that anyone who is an ISP is allowed to moderate their content. And it isn't a publisher versus platform or an editor versus ISP distinction, but rather it is you can be a traffic cop.
Yeah. So can we use the word censor? Can Google, can Twitter, can Facebook, can ISPs, can platforms, are they within their rights to censor third party or user or publishers content in any way, shape, or form? Do they have that ability and that right?
Section 230 says that they have that right as long as that moderation is done in good faith. Now, it doesn't say it the way I just said it. It doesn't say as long as. What it says is that moderating content for purposes of, again, keeping things moving, keeping it clean, and having rules of engagement, as long as it has to be done in good faith. The word in good faith is in there.
I see. So when some government official or some celebrity or somebody says something and Facebook, Twitter, boots them off of the platform or prevents that post or something from being seen, they're certainly acting within their rights. The question whether is are they doing it in good faith? Are they being good stewards, I guess, if you say. Is that really the question?
Before we go any further, let's take a step back.
Okay.
Prima facie, out of the box, they would be within their rights in a state of nature, so to speak. It's their platform. They built it. Let's forget about the political and historical and commercial issues of whether they built it using government money.
Okay, well, that's very good.
It's a private platform right now. It's a private company, so presumptively they would be within their rights.
Okay.
If they do it in a way that would otherwise result in a legal claim, in other words, you destroyed my business, or you made me look bad because you took me down and said we're banning you from this platform because you're a violent person, and now no one wants to hire me, or you're a racist, and now people cancel their contract with me. That's the kind of thing that normally gives rise to legal claims.
I see.
Section 230 comes along and says, okay, even though that would give rise to legal claims, we're going to inoculate, we're going to make you exempt from any liability on those claims as long as you're doing it fair and square. So what does fair and square mean? This isn't in the statute. This is now the advocate talking, because as far as I know, this has not really been tested in the courts. I'm among those who is trying to test it in another case right now. But if you have terms of service to say you can't you can't wear green, you can't talk about flowers, you can't eat a muffin on video, whatever rules they want to make, that's up to them. But if they don't enforce those rules in what does in good faith mean to my reading? It means arbitrarily and capriciously. That's a legal term under administrative law, which means in a way that is not consistent with a fair regime of rule application, but rather you show favoritism. So if you allow someone who—
a little more arbitrary.
Right, arbitrary, or again, arbitrary means just like every fourth person is getting booted off. So that's kind of arbitrary. Capriciously means you're showing caprice. In other words, you're showing
You got an agenda.
I have an agenda, and people with beards, they're off. I don't like them. They're going to go. And if that's going to be the rule, then that's caprice. And in my opinion, and I think there are others who agree with me, that is where you may lose your Section 230. You still have to make your legal claim, by the way. You still have to demonstrate that wrongful conduct took place, that it took place with some degree of intent. Probably. I mean, you could have a negligence-based claim. You have to show that you've suffered damages. The mere fact that someone has a Twitter account or Facebook account deleted might be disappointing to them, might be hurtful to them, but the ability to show economic damages from that kind of harm, entirely different question.
Right. Well, let me ask you a question. So we've clearly established that ISPs, platforms, big tech companies, that when they do have the right and the ability to censor or moderate or play judge and jury on publishers and us users, the content that we put on those platforms. So that's fair. We've also established that when they're playing judge and jury, they've got to do it in good faith, as set up by Section 230. My question for you is, obviously, since this is your space, as you scan the horizon, and over the last, 5 years or so, how are the big tech companies doing at playing, operating and playing judge and jury in good faith? By and large, is everybody doing a pretty good job? Are they abusing that? What's your take?
it's a complicated question. I think 5 years ago, the answer would be very different. The answer was there had been very little moderation.
Mm.
And you had to really go very far to get kicked off. And 3 or 4 years ago, and I think it's fair to refer mainly to Twitter, Google, and Google mostly in the terms of in the sense of YouTube. Let's keep search out of this discussion. It's a much more complicated issue.
Okay, sure, yeah.
But a very important, extremely important one. Just ask Tulsi Gabbard.
Right.
Twitter, Facebook, YouTube. We're not doing all that much monitoring. When Twitter in particular started to really take off about 4 or 5 years ago. There was an increase in attention to hate groups, and I remember I've been a Twitter user since 2009, and I remember finding it to be a very unpleasant experience in many respects, because if I would get into a conversation where anybody was noticing at the time, I would frequently get attacked by vicious anti-Semites, and it was an unpleasant experience. And you could understand. And when I say vicious anti-Semites and attacked, I can handle myself. I'm a professional arguer.
Right.
But having people send you pictures of crematoria and dead bodies and death camps, let's just say it makes me not want to use the service. And you can understand why I say, in order for these services to survive, they need to be able to clean up Dodge from time to time. What happened around the time of Donald Trump's election, however, was that the process became extremely politicized. And there's the increase in censorship based on political criteria has been through the roof. And
through the roof, meaning exponential or a slight uptick, relatively speaking? I mean, through the roof, meaning?
It's a great question, because the number of people who have actually been banned who are not the kind of people that I don't miss, let's just make it the Ron Coleman criterion, all right?
Okay.
It's really not that large, okay? Maybe there are a few dozen or a few score people. So you might say, so out of the millions and millions of users, is it a social problem if 30 or 40 or 50 or 60 people are banned who are decent people who we might otherwise want to hear? Answer, yes. Yes, because those people frequently had hundreds of thousands or even millions of followers, and they were influencers. Their views, their take on things, whether you wanted to accept them or not, were influential, and people wanted to hear them. Now they're being deprived of hearing them. So we can't measure by the number of accounts. What we can say is that
maybe more impact,
and also it also sets a tenor. There's an entire tone. There's no question. There's something called chilling effects under First Amendment law. Again, this is not a First Amendment issue, but it's a free speech issue when the analysis is similar. There's a chilling effect when the guy next to you is pulled off internet, and you say, "Boy, I'm sorry, it's pulled off to say Twitter." And you say his tone and his content were a couple of clicks past mine, but not otherwise so far off. That makes you say, I better be careful.
That kind of sends a warning shot across the bow, as they say.
Right. So that's a social problem. It's probably in the long run a business problem for these platforms. But in the short run, they find it impossible to resist the pressure of organized groups that have agendas which enable them to label people as extremists or members of hate groups, or even, in some, there's been a phenomenon that's been reported over the last year of people getting letters that they are violating the blasphemy laws of countries like Pakistan and even the UK. I'm talking about people in the United States are getting these letters.
So now that brings up an interesting question. If I'm an ISP, if I'm a Google, or if I'm a YouTube, or if I'm a Twitter or Facebook, and my product and my service is a worldwide distributed product or service, what responsibilities do I have as a domestic company that, all over the world? How should platforms, how should ISPs deal with foreign governments saying, your people, your users are saying stuff that are against our culture, our country's laws? That seems to be a kind of a tricky, tough thing. How do they deal with that?
It is, and we haven't figured out how to deal with it. In fact, it's not even really being discussed yet. I haven't heard anyone at the national level, including in Congress, talk about this problem, but it's a very serious one.
It's probably going to be a bigger thing coming in the future.
It is going to be, and the problem is that there is a very great reluctance. Some of it is a reluctance that springs from people getting very large donations from some of these companies. I think it'd be foolish to pretend otherwise. But some of it is a cultural reluctance among conservatives as well, especially libertarians, to do anything that would interfere with the rights of private companies to conduct business as they see fit. And in my view, the problem with that is, in an absolute sense, are we interested in liberty or not? If we're interested in liberty, and you have forums that are of such significant political and cultural impact, that even though they're private, there's still a liberty interest of some kind. Doesn't that bother us? And shouldn't it bother us? I think the answer to that is yes. And second, if our interest is, well, at least private enterprise is fine and government should keep out of it, and good news, government's keeping out of it. What if the government is the government of Pakistan, or what if the government is the government of Qatar, Qatar as they say,
yeah,
or the government or the EU? That's a problem. I don't know the answer to it, but I do know that right now the question isn't even being asked.
Well, sounds like it's coming, and it sounds like
it's here.
It's here. Interesting. Well, I'm glad I am not the senior executives that have to make those big, tough decisions, but those will certainly have some significant impact on publishers, us users who are putting out our own content, and whether or not the platforms will censor or play judge and jury based on foreign governments' rules, requirements, petitions, requests, threats, et cetera. That's an interesting deal. Now, I know earlier in July, mid-July, President Trump put together a social media summit. I know this has been on his mind and in several about just the environment of social media and censorship and all this. I know he put together a social media summit. I know you were one of the selected guests that were kind of the VIP guests that were invited to go. Talk to us a little bit about what that summit was all about. What were the topics? What were the conclusions? What did you observe? I mean, what were your kind of key takeaways? What was the tone? How did that all play out?
It was clear to me within a couple of, we were given about 3 weeks, I think, or 4 weeks maybe, notice of this event. When you're invited to the White House, if you're a regular guy like me, you clear your schedule. You
right.
find time to go to the White House.
Right.
It was also clear to me as we got to within a couple of weeks, as a lawyer who's used to researching and preparing and having a presentation ready to go if he's called upon, that I wasn't going to be called upon. And that it didn't seem to me, based on people that I was speaking to, that anyone I knew was going to be called upon, or at least not for much. We weren't given any kind of guidance by the White House about what the event would be. So what I deduced, and I think I was right about this, but not quite the way I thought I would be, was that this was fundamentally a political event. It turns out that there were a couple of breakout sessions beforehand involving some of the more high-level, I would say, influential people that the president wanted to hear from on this, who did get to meet with the president and some staff members to discuss the issues. But the main purpose, I mean, there was a working aspect of that, and to some extent, speaking with some of those people beforehand and talking about some of the issues, I heard the fruits of that conversation to some extent in the president's remarks and in those of other members of the White House staff who were involved in this issue. So there was a working aspect to it. And there were members of Congress there, members of the Senate. Josh Hawley was there. A number of cabinet members, the people who are looking at this issue and who have influence over it were engaged. There was another, though, and probably in the medium run, more profound purpose of that meeting, which was for the president to make a political statement to the extent that the issue of the role of the press as a political force is something that is of great political significance to him and really to all of us.
Yeah.
He stood as we sat in the East Room and the president addressed us, and behind me to the left against the wall were the members of the press with their cameras and their video and their recorders, and he basically stood there and told us, and I'm active on social media myself as well as representing people who are active on social media, said to the invited guests, "You're the source for which Americans are increasingly turning for unbiased or at least checkable in news and information, because the guys in the back are the fake news. They have a political agenda, and I don't think really there's a serious question that that's the case. So the mainstream press is not mainstream at all anymore. It's simply a different bunch of corporations who are using the brand names of what was once considered to be, the mainstream media, but they're a different kind of advocacy group. The president was making a statement saying that to the extent that anyone thinks that Donald Trump, can legitimize anything, and there are people in the country who don't think that's the case at all, but those who are interested, those who are paying attention, I'm showing my age. I used to have this conversation about bloggers. I was actually involved in the question of whether bloggers can be treated by the law as journalists. But today, you people who are active influencers on social media, you're the press, you're the embodiment of the First Amendment today. And the fact that people are being banned from platforms is something that's of concern to me, because there's been a lot of feedback, a lot of frustration, in a sense that the White House didn't seem to care that the people who were being banned were predominantly friends of this White House and of this president. So this was a moment where the president made that statement. I hear it, I feel it. At least one person who happens to also be a client of mine who was banned wasn't in attendance there, and I could feel the seething anger from the press corps in the back. They didn't appreciate it one bit, and I don't think they were surprised either.
It doesn't sound like that's a revelation or a shocking message, but it doesn't mean they liked it. It sounds like, obviously.
Well, it's one thing to think that he thinks it, and it's another thing to hear him say it.
Right.
And there was a lot of the ground was really softened for undercutting it before we even got there. It was described by the professional, the people who do this kind of thing, a group of haters, a group of trolls, a group of extremists is being invited to the White House. Now, as you know, these terms have really ceased to have any meaning anymore. They reinforce a certain political orientation. They make people feel good and self-righteous about themselves. But most of Americans, in a world where I'm an Orthodox Jew, and people have repeatedly called me a Nazi because of my legal work or because of my views, which are definitely not Nazi views. The words don't have meaning anymore. They've divested them, and it's a shame, because these are important values.
Right.
We don't want racism, we don't want extremism, but when everyone's an extremist, right now, if you go on the internet, the number one target, and a person who's being accused of being basically a closet fascist is Tulsi Gabbard, who's a Democrat and a very liberal politician. But that's what it's come to.
Yeah. Well, so from the summit, I mean, at the end of the day, when it was all done, were there any decisions, any conclusions, any, from here on out, we're going to start doing X, or was there any kind of
Not to my knowledge. I do think, however, that it was an important political event. And when I say that it differed from how I expected it, I thought it was going to be a little bit more symbolic and a little bit less substantive. The president spoke at length, took questions. As I said, there were high cabinet members there and leaders from the legislative branch. So I think it was more substantive in terms of messaging and in terms of sort of a cultural and political message. That matters. But in terms of action, I'm not aware of all that much that has been taken, nor am I aware that all much that can be taken. Mm-hmm. I think this is largely a legislative project right now, and I'm not sure there's all that much for the president to do, besides lead from the bully pulpit, which is his job, and which I think this is a part of.
Yeah, well, that's interesting. Well, as you know, CloutHub was founded as a social media platform with certainly free speech and privacy as its core principles. And you've been a member of CloutHub. You set up your profile on CloutHub some time ago. I mean, share with us ultimately why you decided to align yourself with CloutHub. Why, what is it about it that resonates with you, and what drove that decision?
Well, Jeff Brain, founder of CloutHub, reached out to me actually and said, Ron, I'm Jeff Brain. I've got this great alternative platform. I had previously represented another alternative platform, and I don't want to name them, not because I'm ashamed of it or anything, but I just don't want us to be seen as criticizing them. Their approach is absolutely no censorship, short of someone actually harassing or threatening someone. You can do whatever you want. We're simply not going to be involved in any content moderation whatsoever. And I have a lot of friends, a lot of people I respect greatly, who think that that's the only way to go, that that's a great idea. But I think that's frankly impossible. What inevitably happens, and this is what happened at this other alternative, is that it became basically a Nazi hangout. Mostly, look, these are not real Nazis. The Nazis,
right. Term.
They lost World War II. They're done. They're people who are neo-Nazis, or would like to think that they're neo-Nazis, or who like to front as being neo-Nazis, or who are pretending to be neo-Nazis and are just working for left-wing organizations. Whatever they are, they're obnoxious. They ruin the fun for everyone. Everything becomes about the Jews. Everything becomes about the blacks. Everything becomes about globalism. It's impossible to. On the other hand, there's no reason on earth that you can't have a good faith, moderated environment that really endeavors to do what it seems that Twitter, Facebook, and Google are simply refusing to do, which is to make the effort to be fair and to really to remove only the really bad apples that are making other people's experience intolerable, not healthy or unhealthy, Jack Dorsey's term. That's nonsense. Those are weasel words, and that means that we're going to pick and choose winners. But to say that, how do you ever draw the line? Ron, how do you ever draw the line? The answer is we draw lines all the time. As a lawyer, I'm always convincing judges that the line is over here, or trying to convince them. And my average judge is trying to convince them the line is over. No statute and no legal precedent can ever predict every specific case that comes up. You have to have lines. You have to have traffic lights. That's not what attracted me to CloutHub, though. What attracted me to CloutHub was the comprehensive scheme for working, networking, and sort of creating a virtual online community and resource that is very, very powerful potentially. And I spent a long time talking about it with Jeff and being very impressed. As somebody who just loves to do all his work online and to store things online, and look, here's my desk, okay? There's almost no paper on it, okay? You go into a lawyer's office, you'll see stacks and stacks of paper. I don't want to touch paper. I don't want to touch it, except if you give me paper, I'm going to lose it. And I might lose what you send me electronically, but I can find it very quickly.
Right.
That's how I like to work. CloutHub has all these tremendous resources, and if things do get built out and adopted, and that's going to be a great challenge, in the way that Jeff explained it to me, then the forum aspect of it will be important, and will be another fun part of the experience. But it overall becomes a place that it can really be a productive way to spend time online, in a communal way, and in a way that adds leverage to what you're doing with your computer or with your cell phone.
Well, transparency, terms and conditions, privacy, freedom of speech, those are all critical values that CloutHub focuses on, and we sure appreciate the time. If those watching this show are curious about CloutHub, would like to set up a free profile, just go to clouthub.com and click on the appropriate icons to download the app. You can create a free username and password, create a free profile there, and check it out. But Ron, it's so good to be with you. I've enjoyed immensely the chance to ask some questions and hear your take on these various issues. You really are a wealth of insight and wealth of knowledge, and we appreciate the time that you've taken.
if you want to learn more about Ron Coleman, his work and the things that he's doing currently, just type his name into Google and you'll get all the information that you want. Ron Coleman. You can also learn more about him at likelihoodofconfusion.com. Likelihoodofconfusion.com. Tons of blog posts there, tons of great information. Ron, thank you so much. Appreciate you. And any parting words for our guests or our readers and our viewers here today before we wrap up?
Be nice, be decent, be open-minded, don't be a jerk. What else can I say? Have a nice day, enjoy the weekend.
Hey, thanks so much. Take good care. We'll see you guys once again on the next episode of the CloutHub Show. Take care.